like someone had made a really bad mistake. Then my surprise was confounded that I was just one of 700 families that were all emotionally and financially thrown under the bus by this policy. It didn't take long to sort it out. On 7th of September 2011, the same week that I was hired, DOD lost a court case, the John Thomas LQA court case. The federal judge in his ruling found that there were major flaws in the DOD LQA policy. Now, in the military collectively, we believe in being responsible for our actions. But attorneys and politicians sometimes look at things differently. So soon, the DOJ lawyers came up with a plan to help the DOD avoid liability with this problem, which involved over 30 years of mismanagement of LQA. So what they were told was go in, change the policy, and then retroactively apply it for back, you actually went back 28 years on it. And voila, there you have it, 700 families thrown under the bus, and really in quite what we see as a fairly reprehensible way. So that is all background. Now I'm getting to my first question. I understand that you were a general in the Pennsylvania National Guard. As a former commander, I'm sure that you understood and jealously defended the rights of commanders to make decisions that affect their commands. Yet in this case, you've had, I believe it's 5 4-star generals, numerous 3-stars, the head of AUSA, who's a retired 4-star, the head of the Veterans of Foreign Wars, numerous congressmen and senators write to you personally or to the Sept, stating that the bad impact that this policy change had and asking you to change it. You have personally taken the lead on this LQA initiative and this retroactive change in the rules, and essentially all the general officers have been told to sit down, shut up, and color inside the lines. And in the last year and a half, they have done that. Nevertheless, the 700 families have all been pushed under the bus. So here's my first question. Almost all of the 700 of us were granted an exemption to policy by our commanders. Those commanders have very specifically delegated authorities that are given to them. Those specific delegated authorities, in other words, the authority that Congress gave to the President gave to the Department of State gave to DOD, and DOD lets that authority reside in your office. Those regulations actually give that exact same authority down to your combatant commanders and your component commanders. So what you've done is you've gone back in most of these cases, and the vast majority of them, these are cases where combatant commanders and component commanders gave exceptions to policy due to unusual circumstances. And you threw all those out. Those commanders have the exact same authority that you have. So I'm not really here to argue with you on what is the meaning of is or what does such mean in the OPM rulings, because I know a lot of people get caught up on what does such employers mean. But my question for you, my first question is, why have you disregarded not only the input from your generals, but have actually undermined their authority? Because what they did is an authority that was delegated to them and has been delegated to them over time. That's question number one. Why have you done that and taken the advice of attorneys over the advice of your commanders? Question number two specifically involves pecuniary liability. If we suppose for just a moment that your component and combatant commanders all illegally used their delegated authority and discretion, and that the unusual circumstance waivers that they gave were not valid, which I personally don't believe, but let's assume that for a moment, you yourself have repeatedly stated that this happened through no fault of our own, speaking of the 700 people. So it wasn't our fault that this happened to us. So the DOD regulations regarding pecuniary liability are crystal clear. If a finance officer or an approving official or an approving authority obligates money on the part of the United States government, then that person is to be held pecuniarily liable for that money. Yet what's happened in this case is we have 30 years of approving officials and approving authorities granting LQA under the authority granted to the combatant commanders to make these exception to circumstances. And yet, none of those approving officials are held pecuniarily liable. So if we were being fair and honest in this world and we're saying, hey, we're going to hold all 700 of you accountable, like say in my case, for a year's wages, well then why aren't those approving authorities who approved all of this and who, even though it strains credibility to think that all of those people misread the regulations for 30 years, why are none of them held accountable? Now, I would propose to you that if we tried to hold them accountable, that they would produce the internal documents and memos that would prove that there in fact hasn't been a misinterpretation of the regulation for the last 28 years. But in fact, they were properly regulated, but what we do have is very clearly a retroactive application of a new change in the regulation. So my last question is, we all know that LQA is discretionary policy. DoD has hung a great deal of weight on the fact that as a discretionary policy, they can pay it to who they want, when they want, and how they want. You've been given a great deal of latitude in this by both the Office of Personnel Management and, until recently, by the courts. Your office and the talking points that you continually publish makes a great deal of this fact that this is a discretionary payment, so you don't have to pay it. So what happens is when some of us went into the DFAS appeal, we said, okay, you've got a discretionary payment here, but for you to have the force of law, you've got to file this with the Federal Register. Now, Congress has said that any agency of the government that's going to spend money, which is the right of Congress, has to file with the Federal Registry. Now, I get that there's some confusion around this, and the only thing that the Supreme Court has said on it is, hey, if you're obligating money, you have to file in the Federal Registry. So when we came back and said, hey, DoD, to your office, you haven't filed this in the Federal Registry. Now, on that appeal, Seth Schulman, who works for you, came back and said, oh, but this isn't really a rule. This is a little bit looser than that. This is a little loosey-goosey. We don't have to file it in the Federal Registry. So now we've kind of come full circle again, because what your talking points constantly say is the law obligates us to do what we're doing. And yet we've come back from Seth Schulman here and said, well, you know, this isn't quite that solid. So my third question to you is, we're back to your discretionary powers, because just like the President, Congress delegated to the President, who delegated to Department of State, who delegated to DoD, it sits on your desk. The discretion to change this regulation, to apply it how you want, is yours. It's yours. So to quote an old and oft-used saying, I would say, Secretary Wright, tear down this wall of betrayal that has been built around these 700 of us families. Some people who owe over more than $1 million. You can do this. You can be morally and technically correct on one hand, or you can listen to your attorneys on the other hand. So my question for you is, as easily as you change that regulation and disqualified all of us retroactively, you can go back and you can reinstate us. The law doesn't proscribe you to keep you from doing that. So that's my third question. Why don't you change this back to fix those of us who've been put in this prison of betrayal and trust? Thank you.
Well, thank you for your question. First, I would like to thank you for your service. And thank you for congratulating me. I've been in the position for 2 years and finally confirmed. So I was happy that that happened. On LQA, that was clearly a very thorny subject, not only for me, but all of DoD. To include Secretary Carter, who at the time was the Deputy Secretary, and we worked clearly with him. I would like to admit that I have as much power as you think I have, but I don't. We have a regulation. I would like to admit that I heard from all of those generals that you said I heard from. I heard from General Breedlove, and I heard an email from General Rodriguez. That was it. They never asked me to change the policy back. They asked me what was happening. respond to them probably on an every 2-month basis on where we are with LQA.
Ma'am, I could provide you with copies of the letters if you'd like. I do have them at home.
That would be fine, because they did not, well, and so let me just say it this way, they did not get to my office. But I have worked with all of the COCOM commanders, because it has affected General Scaparrotti, it has affected General Breedlove, and it has affected General Rodriguez. I'm not going to get into the specifics because we have a couple court cases. That would be very unfair to, one, the people that are filing the court cases, and two, it would be very unfair to DOD. So I won't get into specifics. What I will tell you is, as a body, that the person that brought this to our attention was General Breedlove's command. And General Breedlove's command said that we think we are applying the LQA rules inappropriately. And though a commander may think they have the authority, and as a commander I can speak from this, if I thought I had the authority to do something, but I didn't have the legal authority to do something, me giving a waiver didn't mean it should happen, because that was inappropriate. And so at that point we realized, and there were 659 people that were inappropriately given LQA for a period of time. We worked with DFAS, we worked with the comptroller, we worked with Doha, and we sent people out to talk to everyone that had an issue with LQA. A terrible issue. I'm not making light of this. This is a horrible thing that happened. It put people like you and 658 others in a very, very difficult position. I will tell you that I believe that attorneys do one group of things and leaders do another. We have a responsibility to listen to the attorneys, but not always take their advice, because we, and I'm speaking as a previous commander, the commander is the commander, the attorney is the attorney. They give the advice, we have the responsibility to weigh that advice with everything else that we know and make the best decision that we can. So with the attorney's advice, and I don't want you to think that it was just the attorneys that made this decision. It was Bob Hale, it was Secretary Carter, it was Terry McKay in DFAS, it was all of us together that looked at LQA across the DOD and said, we have made a mistake. And that because of that mistake, these are the things that we are going to try to do to make it at least an ounce palatable. Clearly, not wipe away the grief, not wipe away the pain, not wipe away any of that, because we understood. But we wanted to make sure that, one, we continued LQA at the present rate for a year for the individuals that were disadvantaged, and two, that we worked clearly with Doha that if the individual did not do anything illegal, immoral, or fraudulent to the government in the LQA, that debt would be totally wiped. Now, yes, now the individual has to live without the LQA that they were living with. And I regret that. But I cannot change and do something outside the scope of my responsibility. So that's the LQA story.
I can help you a little bit, because apparently some information doesn't appear to be making it to your office. I don't know, you'll probably recall last September, maybe this week, a year ago, I met with Dasti Hinkle-Bowles on this, and she had an 06 in there who came out of UConn. He is the 06 who in the G1 brought this to General Breedlove's attention.
Okay.
It was not brought to his attention to say, hey, we don't know if we're applying this right. Their deal was, after the John Thomas court decision, they said, we don't know what the hell to do with this, because it turned LQA on its ear. Because that judge found two things. He found that, one, the discretion that the DOD, and you probably know this, the discretion that DOD had widely used was no longer theirs to use. Because he said, because you're not following the intent of the president as he gave it to the Department of State, I'm going to throw your regulations out. And that's what he did. And he said, does this person apply according to the Department of State regulations? And they did, and he gave it to But that wasn't the only thing he found, and there's been other court cases recently, including the Roberts case and the Travanovich case, that originally found this, that says, you know what, your discretion is only in creating the policy. In other words, for the last 30 years, probably 50 years to be honest, DOD has pretty much been able to say, hey, you get LQA, you don't. And it's just that simple.
And
If they
LQA
choose-
is not a benefit, sir. LQA
No, I
is an
understand all this,
incentive.
it's discretion. No, but see, that's where the judge didn't agree with DOD. He said, you're using it as a hiring incentive instead of, as it says in Congress statement and in the sorry, I got distracted. In Congress delegation to the President delegation to the Department of State, he said, this isn't a hiring incentive, this is to reimburse federal employees overseas for fair and adequate housing. So anyway, I don't want to belabor this, it's a very technical issue, I can see everybody's getting a little antsy, but the bottom line is, Breedlove didn't come to your office, and I realize this was before you because it was right after that court case. They didn't come saying, we don't know if we're doing this right. They came and said, we don't know what to do because of this court case, because that's a rule changer. And that's where the attorneys entered in, and I happen to have had pretty good sources back then, at the SES level up in OSD. And it was the attorneys who came over and said, stop everything, and retroactively apply this. And this is a retroactive application, so you do have a lot of power. I guess we'll agree to disagree. So there were 3 questions. Why do you undermine the authorities of your commanders who have the same delegated authority you have, who made these decisions in the first place? Number 2, pecuniary liability is the one you haven't addressed. Why was no one else in this held accountable? Why are all the people who actually made the decisions?
There's a difference between something that is done perfectly, where somebody should be held responsible, and a valid mistake. And that's the same reason that we work so hard to get the individuals not held liable for that money and have to reimburse that money. That's the same reason we work with DFAS and DOHA, so that the debt would be waived.
May I ask one last question? May I ask one question? The same authority that you used to grant the 1-year waiver, it's the exact same authority that could be used to grant it till each of us rotate out. It's the exact same authority.
And yes,
There's no limit on that. You've placed your own limit on that.
we did, because one, we felt that there was an error made, you were getting this money, and to cut you off on a Tuesday and have you go cold turkey on a Wednesday was inappropriate. So what we tried to do was say, look, no fault of their own, no fault of the HR, we are going to grant it for a year so we can kind of wean and understand that there is an end date to this, and give some grace period, if you will, and then have you go through the responsibility to DFAS and to DOHA to get it waived. I understand we're not going to agree. I do. And I'm not making light of the situation. This has probably been, in my 2 years in this seat, which is an uncomfortable seat, 2 years, probably the hardest issue that I have dealt with. And do you know why? Because it affects people. That's why.
Destroyed careers and it destroys lives.
I don't know if I will sign up for destroyed career, and maybe we can disagree
I could give
about
you
that.
examples, but we won't go into that here.
Understand. But I do thank you for the time and energy that you've taken to ask the question.
Are there any other questions?
My name is Kim Alvog, I'm with Child and Youth Services, and I'd just like to ask about budget cuts for Child and Youth Services. I know our budget is kind of up in the air, and I'm just wondering if you could give any insight.
So the budget is